code that was cited in the request is Ohio Revised Code section 2744.07A1. But just the plain reading of that statute, it refers to any civil action or proceeding which contains an allegation for damages, and then it goes on from there. But I mean, clearly this is not a civil action or proceeding, this is a disciplinary proceeding, and there's no allegation for damages. What's at stake is Mr. Grendell's legal license, his law license, and his ability to continue as a judge. So I mean, just the law he cites is clearly inconsistent with the request.
Yeah, when I had the discussion with our legal counsel, outside legal counsel about that, basically the reply was that the board has the authority to provide the funds, but there is no requirement for them to provide the funds. And with regards to the request for outside counsel, that would actually not be approving the hiring of the outside counsel. That would be requesting the prosecutor to seek a joint application with the court to approve hiring outside counsel.
And as far as the legal fees that have already been incurred, it seems to me that the procedure is a bit out of whack here, because the request has come after this $300,000 in legal fees have been incurred, and the commissioners have had no ability to decide what the proper rate should be of this attorney, who the attorney is. It's kind of coming in after the fact and asking for the reimbursement done.
So from what I understand, and correct me if I'm wrong, Gary, this was a scenario that the Supreme Court appoints the counsel to this, that the commissioners truly do not have, in this function, we do not have negotiating rights at the time of the Supreme Court basically putting whoever they have on that board, correct?
Correct, that was my understanding, is that the Supreme Court appointed this outside counsel for Judge Grendell in his case. And then, kind of like insurance, when insurance appoints outside or counsel for somebody, then that rolls over. We've never received anything from the probate court on whatever might have been signed off by the judge prior to that counsel being appointed. So it's not known what was ever what was decided or who ultimately is responsible. But Commissioner Brakey is correct. This really should have been done 2 years ago when the council was originally getting to the point where they were no longer going to be covered by the Supreme Court funds, but were going to be the responsibility of whether Judge Grendell or the county. That's when this discussion really should have occurred.
Right. And I think that, as Judge Grendell had stated when he was here, that the bills were not coming to us, and from what I understand, according to what his statement was, is that they basically were surprised by the bills showing up at their office at a later date, and so there was a situation, there was a big miscommunication or misdirection of the invoices along with what's actually going on with the billing on that. And I know to his discontent also, he agreed that the $300,000 was, he felt extreme, that he would definitely be, more than willing to try to assist us in getting those bills reduced. For me, I think that there's one way or another we're going to have to reach a settlement. I would imagine that we're going to have to pay this, whether we decide to do this here or we get this in a position that they're going to file a suit against us and litigate to get their costs paid. I think that they got appointed by the Supreme Court and they want to get paid for their services. How this all shakes out at the end is going to be something that we'll have to make a decision on later. But one way or another, I think that somehow somebody is going to get paid on this because the Supreme Court ordered this law group to make this, to handle this procedure, and they're billing for it. And so I would imagine that their time is going to probably have to be paid for, and how we'll pay for it is yet to be figured out.
Well, I mean, I think at best, it's our discretion whether to pay for it, and I think it sets a dangerous precedent for taxpayers to be subsidizing an elected official's wrongdoing. And if we're forced to do this by the court, then that's one thing, but voluntarily entering into it this time, I think that sets a dangerous precedent.
And I guess the only other thing I could tell you is my discussion with the judge on this was that statutorily, you know, he is an employee of the county that was basically put in this predicament, in this position, and that, you know, that he's entitled to legal representation. If that's the case, I don't know. I'm not the legal counsel on this. I'm not an attorney, so I'm not going to comment on what the way that this is gonna go, but I would think that one way or another, this is going to show his head again, and we'll have to figure it out then.
I mean, I would say I personally find it's a gray area if Mr. Grendell is even a county employee. My understanding is he is partially paid by the state and partially paid by the county. So I mean, I didn't even really get into the weeds of that analysis, but as far as, you know, does the statute he cites say what it does? It absolutely does not. And a first-year law student could figure that out.
Okay.
I feel if we're made to pay a portion of it through the courts, then I'll wait for that day.
Commissioner Brackey?
Yes.
Commissioner DeWark?
Yes.
Commissioner Spillier?
I'm an abstain. I just don't have really enough facts to make a good, sensible decision on this.